Right now, first Judge Hudson in Virginia and then Judge Vinson in Florida said, not so fast with Obamacare. The mandate, the individual mandate, may be unconstitutional. Judge Vinson went even further and said, because of that, the whole law is unconstitutional. The Attorney General of Virginia, Ken Cuccinelli, who to a very large degree started this fight when he protested Obamacare in Virginia, has said he's going to ask the U.S. Supreme Court to take a direct review of this constitutional challenge, and we're going to find out right now how much or how little success that's going to have, because Attorney General Cuccinelli joins us now. Mr. Attorney General, good morning.
Good morning, gentlemen. How are you doing?
Good. What do you think the chances are of the Supreme Court taking this up? And talk us through the process. How does this work?
Supreme Court's Rule 11 allows for the expediting of cases, meaning they can grab it at virtually any stage, though to file for Rule 11, you have to be docketed in an appellate court, which we are in the Fourth Circuit. Cases of national importance that obviously have a broad impact, and this case fits in that category awfully snugly. They only take one or two of these a decade, to give you an idea of how frequently. So the last one was 6 years ago. We would expect that if they accelerated the case, Virginia's case, that they would also at least grab Florida's case and Oklahoma's, so all the states would be in together. And it may be that they grab over 24 cases and consolidate us all in the Supreme Court, which they can do. They can actually do on their own authority. But we are filing to ask them to consider that. It's purely discretionary on their part. But even the federal government in their briefs in the Fourth Circuit noted that this case is of the highest, meaning the consideration of the constitutionality of the health care laws, of the highest public policy importance. Highest, i.e. there's nothing higher. So that certainly fits the Supreme Court's category, and if you look over the years at the cases they've expedited, there's clearly a lot more national significance, a lot more economic impact, a lot more broadly felt in this case than in many of the others they've expedited in the past.
Do you have any concern that if it were not to go to the Supreme Court immediately and were to wind up in the appellate courts, the Fourth, perhaps the 11th Circuit Court of Appeals, that Judge Vinson's decision, Judge Hudson's decision, might be reversed?
Well, not especially. Because this is going to be reviewed de novo at every level, they're all starting fresh. So, we may win, we may lose in the Fourth Circuit. Florida may win, may lose in the 11th Circuit. But the one that really counts is the Supreme Court. Mm-hmm. Frankly, I'm grateful for Judge Hudson's ruling, breaking the ice, if you will, and finding the individual mandate unconstitutional. And I'm very thankful that Judge Vinson went as far to grant the remedy that Virginia has been requesting, and that is to uproot the entire law, because without the individual mandate, it's simply inconceivable that this law would have ever passed Congress. They didn't have a vote to spare in the Senate and only 3 to spare out of over 400 in the House. So it's not likely that what the federal government itself called the linchpin of the whole legislation would have, in its absence, the law would have passed.
I'm curious is if the Supreme Court does take the case and they lump all of those cases into one, like you said, who then argues on behalf of the states? How does that work? Will you be a part of that?
Well, we'll certainly be a part of it. The Supreme Court can designate leads, or they can just put us all in a pool and say, go work it out, which is often how it works. That's what they're doing in Florida among the 26 states. We have a challenge to the EPA's greenhouse gas endangerment finding going right now with 16 states, and the 16 of us got together and divided up drafting responsibilities for various parts of the case. Now, everybody has editing opportunities, but only particular states are designated as initial drafters and that sort of thing. And in the EPA matter, that's going to be Texas and Virginia. But in healthcare, we'd have to work that out amongst ourselves.
All right.
Speaking of work things among yourselves, Governor Mitch Daniels of Indiana has an op-ed this morning. It's essentially an open letter to Kathleen Sebelius. 21 governors are on board, talking about, absent a court decision in the interim, States are being saddled with horrendous costs, implementing more Medicare programs for more people, setting up insurance exchanges, and Governor Daniels is saying this may cost Indiana between $2.6 billion and $3 billion. As from the chief legal officer in Virginia, how do you come down on the interim decision? Can you implement Obamacare under the law right now, or are you precluded from doing so in terms of things like Medicaid and insurance exchanges?
Well, we're certainly not precluded from doing so. The state can act independently. I mean, the governor can't just go do things because the federal law says so if he doesn't have state legal authority. And one of the issues in the General Assembly this session is adjusting our laws to prepare for the potentially impending requirements of the federal health care law. And, of course, this is a confusing factor, and it's one of the reasons we asked the Supreme Court to expedite the case is, first of all, Governor McDonnell estimates there's $20 and $30 million of costs just preparing to implement this law, and that's without providing a single additional Band-Aid to one single person in the form of health care. Wow. That's just administrative costs to be ready for this. Now, you multiply that around the 50 states, and that's just the state governments. Then we move on to the private sector. The costs of preparation are unbelievable.
Okay, let me ask you this question. Because of the ruling in Florida, can you say, listen, the judge ruled it was unconstitutional, we don't have to move forward on this, we're not going to go ahead with these administrative costs, we're just going to stop it right here?
And a number of states are taking that position. The problem with that is we all know that Judge Vinson isn't the end of the line.
Okay.
And, of course, in Virginia, we have Judge Hudson in the Eastern District who ruled the individual mandate unconstitutional but did not implement a remedy as far-reaching as Judge Vinson's. And in the Western District of Virginia, Judge Moon found that it is constitutional.
Okay.
So we're in a bit of in a no man's land as far as that goes, and so the governor prudently has to at least be prepared in case we lose the case. And there's certainly, I'd be foolish to acknowledge there's no chance of losing when the score so far is 2-2 on the merits of the case among courts that have addressed the constitutionality of the individual mandate.
Let me ask you a question that's not related to health care. It happened in Loudoun County. Now, the state Supreme Court essentially ruled that they can't reopen cases of illegal immigrants who weren't told that if they pleaded guilty, then that could ultimately lead to their deportation. Supreme Court says you couldn't do that. Loudoun County Judge Dean Worcester says, yeah, the Supreme Court is wrong. I don't care. I'm going to reopen the case. Anyway, as the Attorney General of Virginia, is this judge correct? Is he violating the law? How do you stand on this?
Well, I haven't read the specific case. I'm familiar with the circumstances you're talking about, so I don't want to overstate things to this particular case. But if it is squarely within the ruling, the judge simply doesn't have the authority to declare the Supreme Court wrong and rule in another direction. He's a subsidiary court. He's obligated to follow their conclusions of law until they change them, until and unless they change them or the General Assembly changes the statutes to provide for an alternate outcome.
Okay. Sounds good. Thank you very much for joining us. As always, we appreciate it, Mr. Attorney General.
Always good to talk to you, gentlemen.